Our next question relates to workplace law. And so I'm going to go to Wahida for this one. And the question asks, what rights does the employee have when dismissed without a reason?
Very good question. I'm going to actually start with an assumption on this question. I'm going to assume that this employee is not unionized, because if they were, their dismissal and the handling of it, including any grievances, would fall under the purview of the union and the collective bargaining agreement. There are limited exceptions, but that is generally what happens. And that's because non-unionized employees don't have the same freestanding right to job protection as unionized employees. So with that assumption, for non-unionized employees in Ontario who are provincially regulated, they are subject to the Employment Standards Act, or the ESA. So if an employee is terminated without cause or without reason, as the person has asked, their employer has to provide them with reasonable notice of job termination or payment in lieu of notice. Now, that's usually referred to as a severance or a termination package. Now, this package is usually either a lump sum of money, working notice that their job is going to be ending, or a combination of working notice and pay in lieu of notice. Now, if the employer doesn't provide this sort of reasonable notice or payment in lieu, that's when this wrongful dismissal has happened. Now, for these Ontario regulated employees, the minimum standards, which is found in the Employment Standards Act, is a reasonable notice of pay or pay in lieu, reasonable notice of termination or pay in lieu, which is generally 8 weeks. So that's the minimum standards, but the maximum of the minimum standards. Now, if this person happened to be working at this company for 5 years or more, and the company had a payroll of $2.5 million or more, they get an additional week a year to a maximum of 26 weeks. And that will be their minimum statutory entitlements. Now, at law, this is the portion that's actually called severance payment. But in a nutshell, the minimum for the person can be as much as 34 weeks, depending on how long they've been working and how big the payroll of the company is. On the other end of the spectrum, an employee's common law or judge-made law, it's the upper range or ceiling of reasonable notice or pay in lieu, which can be as high as 24 months or in exceptional circumstances, even more. And this might be obvious, but this upper limit actually includes that earlier minimum standards. It doesn't stack. So it's a global number. Now, how much an employee is entitled to under the ceiling depends on a number of factors. It's started with being articulated in a Supreme Court decision in the 70s, but it's called the Bardell factors. And it depends on, for example, the key things are their age at the time of termination, how long they were working there, what was their salary, what was the nature of their employment, and what kind of comparable jobs are out there.